Okay.
Evening. Hope I'm audible. Moderators, hope I'm audible.
Yes, sir.
All right. Okay. Thank you.
We'll just start in a few minutes.
Okay. Yeah.
Fell asleep.
Fred.
देखो वो ऑन तो हुआ है। तो तब वो देखिए क्यों नहीं चल रहा।
हेलो।
आपको इनसे मीटिंग करनी है।
हेलो।
Yes, sir. We're just starting in a minute. Great. A very good afternoon to all. I extend a warm and hearty welcome to each and every one of you to this extraordinary webinar, meticulously orchestrated by experts legal, India's most innovative online directory of lawyers. Experts Legal not only offers a platform for legal professionals to connect, but also nurtures their skills, fosters knowledge expansion, and provides unparalleled opportunities for ranking. It's worth noting that we offer memberships to both lawyers and general counsels. Now, without further ado, let's delve into a brief video presentation that encapsulates the essence of Experts Legal.
Experts Legal prepares the lawyers for the changing world. Due to increased international and domestic business activities, there is a huge demand for quality lawyers everywhere. Clients and companies are searching for expert lawyers in different cities. Lawyers are also searching for lawyers in other cities. Foreign lawyers and companies are also searching for the best legal brains, like you. These are huge professional and financial opportunities. You should grab it. But many lawyers miss this huge opportunity to increase their practice effectively because they are not part of a legal network and their web presence is insufficient. They don't have the opportunity to exhibit their skills to corporate clients, general counsels, etc. Experts Legal solves this problem by a technologically advanced platform with lots of innovative features for networking, skill development, speaking opportunities, international and domestic conferences, listing of a profile, ranking of lawyers, etc. This year we are going to Singapore for our World Congress and Goa for our National Convention and many other places. It is going to be an amazing opportunity for all of you to grow your practice. Experts Legal is a unique platform that can put you on a high growth path.
The overwhelming turnout for this webinar is nothing short of astounding. It speaks volumes about your unwavering dedication to personal and professional growth. You are all a part of an exclusive group individuals who have chosen to invest their precious time today while countless others remain complacent. I humbly request all participants to kindly mute their microphones, and if you have any questions, please ask them in the Q&A session. Now, you are aware about today's topic, which is impact of Mediation Act on the existing business laws. Our speaker, Mr. A. Ramasubramanian, is a dispute resolution professional with over 20 years of international experience and 25 plus years overall experience. He is a fellow member of Chartered Institute of Arbitrators, UK. He is empaneled as an arbitrator with the Maltese International Arbitration Center and the Indian Council of Arbitration. He is the co-author of Handbook on Arbitration for the Practicing Professionals, published by ICSI Hyderabad. With this brief introduction, I present to you the speaker of today's webinar, Mr. A. Ramasubramanian. Over to you, sir.
Good evening and thank you for your nice introduction. To start with, my sincere gratitude to Experts Legal for inviting me to share my experience with the mediation. I welcome all the expert advocates over here, and I prefer to have an interactive session today on this very nascent subject, you can say, because Mediation Act 2023 is a very, very new act. It has become a buzzword already because of its speed at which it was approved in both the houses of the parliament and the speed at which it got the assent of the President of India. Of course, whenever there is a new change is introduced in the system, there is always skepticism, isn't it? How it will be, whether it will change the entire scenario of the legal jurisprudence of the India, whether it will make the advocates jobless. All these concerns are coming in front of us. But the reality, when you consider the international scenario, is mediation, it will only complement the existing practices. Already it has made great impact. I think somebody's yeah, okay, thank you. It has already made great impact by way of complementing arbitration. Already Arb classes are making waves. Therefore, mediation is unavoidable now. And today we are going to talk about the impact, the positive impact of mediation on the existing business laws of India. Before going into the topic for today, I just want to share few things about the mediation itself. As expert advocates, we all will agree that mediation is the only process where both the parties are winners. How? Whether it is litigation or arbitration or any other dispute resolution process, there is only one winner, isn't it? But in the mediation only, both the parties are winner because it preserves the relationships of the parties. And it brings the parties to the fore, not the mediator. Second thing, my personal experience, the mediation process, it not only gives the remedy, but it reforms the mediator himself. Because a good mediator is an expert in differentiating what is a conflict, what is a dispute. An expert mediator will be able to see the other side of the iceberg. It is applicable in dispute resolution as well as in the mediator's personal life. That is why I said the mediation process, it reforms the mediator also. That is my personal experience I want to share here. So with this small prelude, let us begin today's session. With a limited time of less than an hour, I request the participants to allow me to present what I have initially. If you have any questions, you may reserve it towards the end. Let me share the screen. I request the participants to mute their mics so that we have seamless session. Hope the screen is visible. Moderator?
Yes, sir. Yes, sir.
All right, okay. So before we see the topic for today, let us see what are the salient features of the Mediation Act itself quickly. So these are the takeaways for today's.
Please mute everyone.
I request the participants to mute your mics so that Okay, so these are the salient features of the Mediation Act. It recognizes online, community, and institutional mediation in India. Also, it is a centralized act for mediation. Previously, mediation option was part of many laws in India, whether it is Consumer Protection Act, Commercial Court Act, Companies Act, Arbitration Conciliation Act. So mediation was in one way or the other part of different acts. And every act, they have somewhat slight interpretation of the mediation definition as well as the procedure. But now it is a centralized act. Also, this act, it lays down a time-bound procedure and it provides for enforcement and a challenge, of course, of only the domestic mediated settlement agreement. Before it was not so. Also, it paves the way for Mediation Council of India, similar to Bar Council of India, to regulate the mediators and the mediation profession as such. However, on the downside, it fails to recognize and enforce mediated settlement agreements which did not take place in India. That is the International Mediation Settlement Agreement. It doesn't recognize. We will see why. You all may know about Singapore Convention and the Act, which is the framework for international mediation settlement agreements enforcement, similar to the New York Convention for the arbitration awards. Although India, we became the founding signatory to the Singapore Convention, but it is yet to be ratified in our parliament. So therefore, the Mediation Act, it doesn't take care of the Singapore Convention on Mediation, also the International Mediated Settlement Agreement, enforcement of the International Mediated Settlement Agreement. It speaks about the domestic mediated settlement agreement only. I have already mentioned before, mediation was part of quite a few acts. But now, with the introduction of Mediation Act, it is now centralized. Therefore, the definition, it clarifies, it has the one definition. Before, you may see slightly differing definitions. Now, the Act, it says mediation is defined to include any process where parties request a third person to assist them, to facilitate them in reaching an amicable settlement. And the process includes pre-litigation mediation, online mediation, community mediation, conciliation, or any other expression having a similar meaning. So it has brought everything under one umbrella. Now we will see disputes which are not fit for mediation. So the Act, it has identified under the first schedule what are the disputes not fit for the mediation. So these are disputes involving criminal prosecutions, land acquisitions, or pertaining to minors, deities, and persons with intellectual disabilities. Even disputes involving persons who are not parties to the mediation are not covered by the Act. Disputes in regulated subjects such as Competition Act, Telecom, Electricity Act, Securities, Environment, and Taxation. So these are not covered under the Mediation Act. They're all explicitly excluded. And then non-commercial disputes by or against the government or their agencies. So this is also excluded under the Mediation Act. And now mediator. Mediator is a unique person. In my personal opinion, mediator is a more or less, he will be a psychologist. Because of obvious reason that a mediator is an expert listener. He should be able to listen passionately. He should be able to differentiate between interest and the needs of the parties. He should be able to differentiate between conflict and dispute. Kindly mute so that it will help others. Thank you. So what is a conflict? What is a dispute? Dispute is a temporary, and conflict is when you don't address the dispute, it becomes conflict. So the mediator, by effective listening, he is able to identify, he is able to differentiate, and he facilitates. He facilitates the party. He never speaks. He only listens, but he facilitates the parties. Okay, so mediator is a person who is appointed to undertake mediation by the parties or by a mediation service provider. Who is a mediation service provider? We'll see a little later. So that is also a new development with the Mediation Act 2023. Mediator, it includes a person registered as a mediator with the Mediation Council of India. Already I have mentioned Mediation Council of India. That is yet to be formulated, but it will come. It may come very soon. That will be the regulating body of mediator as well as mediation in India. So time limits. So it speaks about the time limit as well, which is a very good thing. Mediation proceeding is required to complete within a period of 120 days from the date fixed for the first appearance of the mediator. Okay. This may be extended by a further period mutually agreed upon by the parties, not exceeding 60 days. So it speaks about the parties' autonomy. Whereas in the arbitration or any other dispute resolution, the extension of the mandate of the arbitrator will be only by the court. Whereas here, if you look at, it speaks about the party autonomy. It says the duration, time limit may be extended by a further period of 60 days, mutually agreed upon the parties, by the parties. So it is 180 days overall. And now we'll see mediation service provider. Earlier, you might have seen under different laws, under different acts, which had mediation as an option, the empanelment will be under the respective act. If you take Consumer Protection Act, it has mediation cell, isn't it? District level, state level, national level. Similarly, Companies Act, MCA, Ministry of Corporate Affairs, they had their own empanelment for the mediators and conciliators. Similarly, commercial courts also, they had, separate list of mediators because deals with the commercial disputes. So different acts, they had different provision for the empanelment. However, with the introduction, with the enactment of Mediation Act 2023, all these will go out of window now. Now it is a centralized one. So that is where this mediation service providers, it gains importance. Mediation proceedings may be conducted by a mediation service provider, which includes a body or an organization or an authority constituted under the Legal Services Act, a court annexed mediation center, which you can see everywhere, or any other body as notified, provided any of these are recognized by Mediation Council of India, which is yet to be formulated. So therefore, in effect, as of now, it means the court annexed mediation center or an authority. Kindly mute, please. Or an authority constituted under the Legal Services Act. So the mediation service providers, they also have the duty to accredit mediators and empanel them, provide all facilities such as secretarial assistance and infrastructure for the mediation. Also, they have to facilitate registration of MSAs, Mediated Settlement Agreement. Mediation Council of India, it is, already told, it is similar to Bar Council of India for regulating the profession of mediation and the mediators. So what are their roles and responsibilities? To provide for the manner to conduct mediation proceedings, recognize, renew, cancel or suspend mediation service providers, maintain an electronic depository of mediated settlement agreements, submit annual report on implementation of the provisions of the mediation to the state and central government. Mediation Council of India would also have the power to frame rules and regulations regarding the provisions of the Mediation Act. So, if you look at the Act, it has 11 chapters, 65 sections, and 10 schedules. Just for a quick summary. So, let us quickly go through the important chapters. Chapter 3, it speaks about mediation agreement. Also, it speaks about pre-litigation mediation, that is governed by the courts. And this act, initially, when it was a bill, it specified that pre-litigation mediation, it was mandatory for the parties. However, after due discussions and recommendation, the act, now it says it is voluntary. Pre-litigation mediation is voluntary because that is the essence of mediation, isn't it? Mediation is a voluntary process. So therefore, the pre-litigation mediation as per the act is a voluntary one by the parties, not mandatory. Chapter 4, it speaks about mediators. Already we have seen who is a mediator, appointment of mediators, preference of parties, conflict of interest and disclosure, similar to arbitration. He shouldn't have any conflict of interest, either with the dispute or with the parties. Then it also speaks about termination of mandate of mediator when there is a conflict of interest, and then replacement of mediator. For the paucity of time, I'm leaving it to you for your soft reading. Just for your information, I'm just quickly running through. Chapter 5, it speaks about mediation proceedings, territorial jurisdiction to undertake mediation, commencement of mediation, conduct of mediation. Also, it speaks about role of mediator. Mediator is only a facilitator. He's not taking any decision. He won't impose any decision. He's only a facilitator between the parties. Role of mediator in other proceedings. It also defines time limit for completion of mediation that we have already seen. So they're all coming under chapter 5. And mediated settlement agreement. What are the components of mediated settlement agreement? How it has to be drafted? How it has to be registered? Then once the MSA has been reached, how the termination happens for the mediation process. Chapter 6, it speaks about enforcement of mediated settlement agreement, which is similar to the decree of the court, and same like arbitration award. So how it is being enforced, and challenges to the MSA's mediated settlement agreement, although the grounds are very limited. So that also I'm leaving it to you for your soft reading. And then limitation period. It talks about the limitation period involved in the mediation. Chapter 7, it talks about online mediation. So it is aligning with the contemporary developments internationally. Because now, since I'm an arbitration professional as well, almost 90% of our proceedings are online. That is one of the positive impact of COVID. So therefore, aligning with the international developments, mediation also embraces online mediation, and that is now part of the Act. Chapter 8, it speaks about Mediation Council of India. Already we have seen briefly how it is established, who is responsible to establish that, what is the nature of the council, what is the composition of council, who will be the chairman, who are the members, what is their duration, qualifications, etc., etc., and the duties and functions of the council. So chapter 8, it speaks about Mediation Council of India. Chapter 9, it speaks about mediation service providers and mediation institutes. This also we have seen. And then chapter 10, it speaks about community mediation. That is a unique feature of the Mediation Act. Community mediation, where the disputes are against a group of people. So it speaks about community mediation and how it has to be conducted, who is responsible for appointing the mediator for the community mediation. It's all covered in the chapter 10. Okay, so now we will see what is the impact of the Mediation Act over the existing business laws. I have already mentioned the new act is a centralized act for the mediation process across all the acts. So we will see one by one. To begin with, we will see impact on the CPC 1908. So if you look at for the section 89, the following section shall be substituted, namely Section 89, settlement of disputes outside the court, where it appears to the court that dispute between the parties may be settled and there exist elements of settlement which may be acceptable to the parties, the court may refer the disputes to arbitration and thereafter the provisions of the arbitration shall apply. And similarly, if you look at B, refer the parties to mediation to the court annexed mediation center or any other mediation service provider or any mediator as per the option of the parties, and thereafter the provisions of the Mediation Act shall apply. As if the proceedings for mediation were referred for settlement under the provisions of that act. Okay, so this is the changes in the CPC. Now, if you look at the impact on the Legal Services Authorities Act, here, 5th schedule, section 60, here it speaks about replacement of the clause. The clause shall be substituted, namely, encourage the settlement of disputes, including online by way of negotiation, arbitration, mediation, and conciliation. Then impact on the Arbitration Act. We know that it is Arbitration and Conciliation Act 1996. However, internationally, conciliation is synonymous with the mediation. And that is embraced in the new Mediation Act as well. So it says conciliation is synonymous with the mediation. Therefore, the Arbitration Act also is subject to changes because of this new Mediation Act. Let us see what are they. So section 43D, which speaks about the Arbitration Council of India, which is yet to be in place. However, the Act, it has Arbitration Council of India. The section 43D, it speaks about the duties and the functions of the Arbitration Council of India. So it has previously how it was. It shall be the duty of the council to take all such measures as may be necessary to promote and encourage arbitration, mediation, conciliation, or other alternate dispute resolution mechanism. Now, this conciliation is removed. So here, conciliation as well as mediation, both are removed. Why? Because they are synonymous, and also now the separate act has come. So therefore, the duties and functions of the Arbitration Council of India is limited to arbitration. Similarly, the same Act, 43D, EFI, wherever you see arbitration and conciliation, now the word conciliation will be omitted now, because conciliation is synonymous with the mediation and Mediation Act is there now. So here, this is the existing provision of the Arbitration Act. So the Arbitration Council of India frame, review, and update norms to ensure satisfactory level of arbitration and conciliation. Now it is only arbitration. Similarly, to act as a forum for exchange of views and techniques, to be adopted for creating a platform to make India a robust center for domestic and international arbitration. Conciliation is now removed. Conduct examination and training on various subjects relating to arbitration and conciliation. It was before, now it is only arbitration and award of certificates. So therefore, wherever the conciliation wording was there, that is removed now. Maybe now the act is truly Arbitration Act. That is the need of the hour to be renamed. Also, we know that Section 61 to 81. They are meant for conciliation proceedings. Section 61 to 81, following section shall be substituted, namely 61, reference of conciliation in the enactments. Any provision in any other enactments for the time being enforced, providing for resolution of disputes through conciliation in accordance with the provisions of the Act, shall be construed as reference to mediation. Because for the obvious reason, conciliation is synonymous with the mediation. So therefore, this section is changed now. So it says, shall be construed as reference to mediation as provided under the Mediation Act 2023. And also the savings provision. It says, any conciliation proceedings initiated in pursuance of section 61 to 81 of this Act, as in force before the commencement of the Act, shall be continued. This is all normal stuff. As if the Mediation Act had not been enacted. It is mostly applicable to the MSME Facilitation Council, where it is conciliation to begin with. And there are thousands of cases are already happening. Okay, now we'll see the impact on the MSMED Act. So MSMED Act, you may all know, that is emerging as a very efficient mechanism for the medium value commercial disputes. In certain pockets of the country, they have a very robust mechanism, and especially from where I'm coming, it is happening in a very efficient manner. It provides dispute resolution at a very, very minimal cost to the parties. So here, most of you may be aware of the stages of the dispute resolution. It begins with the conciliation first, and if the conciliation fails, then it will be escalated to the arbitration by default. So that is how the MSMED Act, MSEFC Council, it provides the dispute resolution. So here, the section 18, it speaks about the reference to Micro Small Enterprises Facilitation Council. It says, on receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution services by making a reference to such an institution. For conducting conciliation, the provisions of section 65 to 81 of the Arbitration Act shall apply. So this is what the existing MSMED Act provision it speaks about. However, after the enactment of Mediation Act, now it is changed. Now it says, refer the same section, now it reads as follows. Reference to MSME Facilitation Council. On receipt of a reference under subsection 1, the council shall either conduct mediation itself or refer the matter to any mediation service provider as provided under the Mediation Act 2023. So there is a drastic change the way MSEFC is going to function now. And that is one of the few acts which predominantly have been using the conciliation process. Now it is shifted to mediation process. However, whatever the cases already happening, that will continue. Also, The conduct of mediation under this section shall be as per the provisions of the Mediation Act, obviously. The next subclass, it says, where the mediation initiated under subsection 3 is not successful and stands terminated without any settlement between the parties, the council either itself take up the dispute for arbitration or refer it to any institution or center. So previously it was conciliation. Conciliation, if it fails, then it will be escalated to the arbitration. Arbitration will be conducted either by the MSEFC itself or they will refer it to any arbitration institution, mostly annexed with the high courts. So now it is changed. Now it is mediation. Once the mediation fails, then it will be escalated to the arbitration. So here, there is another unique feature of the MSMED Act. Earlier also it was there when the conciliation was part of the MSEFC dispute resolution. If you look at the Arbitration and Conciliation Act, the conciliator cannot become an arbitrator. But here it is not so. Since it is a beneficial act, also it overrides the Arbitration Act. The MSMED Act, it had the provision that the conciliator can act as an arbitrator also. However, now with the enactment of Mediation Act, now instead of conciliation, you have mediation. So the council, it may act as mediator also. And the same mediator can act as an arbitrator also, which you won't find in the other provisions of the Act. So here, if you look at subsection 5, notwithstanding anything contained in any other law for the time being in force, MSEFC or center providing alternate dispute resolution service shall have jurisdiction to act as an arbitrator or mediator under this section in a dispute between a supplier located within its jurisdiction and a buyer located anywhere in India. Now, if you look at the Companies Act, Companies Act previous section, it had a unique provision, section 442. So there, I think around 13 regions, the whole of nation is divided into about 13 zones. And each zone, they will maintain a panel of mediators and conciliator. And I'm also one of the empaneled mediator and conciliator with the Ministry of Corporate Affairs. However, now with the new Mediation Act, that is likely to be changed. Why? Because mediation, it provides a centralized procedure for the appointment of mediator and the mediation proceedings. Let us see how. So this is the previous act, previous section 442. It says central government shall maintain a panel of experts to be called as the mediation and conciliation panel, consisting of such number of experts having such qualifications. They have their own rules and the qualifications, the applications, empanelment procedure, empanelment duration, fee, etc., etc. So that is as per this section. Now this section is changed. How? This is the changed section, aligning with the Mediation Act. So here it says, section 442, for referring the matter pertaining to such proceedings for mediation under central government, tribunal or the appellate tribunal, or as the case may be, shall refer the matter to mediation to be conducted under the provisions of the Mediation Act 2023. Now, no more the rules of the Companies Act. Now the empanelment under the Companies Act, only time will tell us. Maybe they will assign to the mediation service provider. It's only emerging, it's a dynamic thing. We'll come to know very soon. However, the change is apparent. The existing clause, it says central government shall maintain a panel of experts to be called as the mediation and conciliation panel, which is now changed here. Here now it is the mediation will be conducted under the provisions of the Mediation Act 2023. So it says about appointment of mediator. Appointment of mediator will be through the mediation service providers. Service providers, as of now, only two bodies are prevalent. One is the panel of mediators with a court annexed mediation centers, and then Legal Service Authority Act. So therefore, the empanelment which was already in place, that may be seeing a change now. They may be assigned with the nearby mediation service providers. Only the time will tell us. Here, again, nothing in this section shall prevent the central government tribunal or the appellate tribunal before which any proceeding is pending from referring any matter pertaining to such proceedings, so moto, to mediation to be conducted under the provisions of the Mediation Act. Similar change. So instead of mediation and a conciliation panel, before it was, the wording was under the provision, it will be conducted by the mediation and a conciliation panel. Now that is changed. Now it is under the provisions of the Mediation Act. So in a nutshell, the proceedings will be conducted in a centralized manner. There is no ambiguity either about the definition or the rules or the mediator or the service provider. So the mediator or mediation service provider shall file the MSA, mediation settlement agreement, arrived at between the parties with the central government or tribunal or appellate tribunal under the Act. Central government or the tribunal or the appellate tribunal shall pass an order or judgment making the said MSAs as part thereof. The fee of the mediator shall be such as may be prescribed. Okay. Earlier it was prescribed under the rules of the respective act. Now, if you look at the Commercial Court Act, so Commercial Court Act, here the pre-litigation mediation, before it was mandatory. However, where the disputes require urgent remedy, then they may get a waiver. Now let us see how the Mediation Act is interplaying with the Commercial Courts Act. So Chapter 3A, it speaks about the pre-litigation mediation and settlement under Section 12A. It says a suit which doesn't contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-litigation mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. Now, for the purpose of pre-litigation mediation, the central government may, by notification, authorize the authority constituted under the Legal Service Authority Act or a mediation service provider as defined under Clause M of Section 3 of the Mediation Act 2023. So therefore, it is clarified now. Who will act as the mediator? So that is now made clear under the new Mediation Act 2023 with respect to the Commercial Court Act. If the parties to the commercial dispute arrive at a settlement, the same shall be reduced into writing and shall be signed by the parties and the mediator. Mediation settlement agreement. The mediated settlement agreement arrived at under this section shall be dealt with in accordance with the provisions of the sections 27 and 28 of the Mediation Act 2023. Therefore, the enforcement will be under the Mediation Act. In section 21A, in subsection 2 for class A, the following clause shall be substituted, namely, the manner and the procedure of pre-litigation mediation under subsection 1 of section 12A. Now, if you look at the Consumer Protection Act, already I have mentioned Consumer Protection Act, it had the provision under the chapter 5, if I am correct. Chapter 5, it speaks about the mediation cell at various levels, district level, state level, and national level. Now there is a drastic change. If you look at the definition clause of the Consumer Protection Act, section 2, clauses 25 and 26, now they are to be omitted. Then B, for section 37, the following section shall be substituted, namely, reference to mediation. The district commission or state commission or the national commission, as the case may be, shall either on application. This is how the existing provision is there. Now, if you look at the new, as per the new Mediation Act, it says, section 2, subsection 25, it defines mediation means the process by which a mediator mediates the consumer disputes. And 26, it says mediator means a mediator referred to in section 75. Now these two are removed. They are omitted. Why? Because the new act, the centralized act, it defines what is a mediation and what is the who will be the mediator. Therefore, these two subsections are omitted now, classes. And also, section 37, it speaks about the mediation in accordance with the provisions of chapter 5. So that is the existing provision, it says. However, with the new Mediation Act, now it is revised. District commission or state commission, national commission shall either on application by the parties at any stage of proceedings refer the disputes for settlement by mediation under the Mediation Act 2023. It is crystal clear now. There is no more mediation cell or empanelment. However, we need to wait and see because it is just the beginning. We have to see how the empaneled mediators will be dealt with. They may be assigned with a nearby mediation, court annexed mediation centers. That is what I think. And chapter 5 of the Consumer Protection Act, it speaks about the mediation cell. Now it is not a relevance now. It says about the mediation cell at the district and the state level. They are all not relevant now. So that is removed altogether. So That's all I have for today. Hope the takeaways are purposive. Now, we have few minutes for questions. Over to you, moderator.
Yes, absolutely. So I would request all the students to please put your questions in the chat box. And it was a very insightful and interesting session, sir. So that was really amazing.
Thank you. It is a learning process for me also, because it is a new act.
Absolutely, absolutely. Now,
Yeah.
this is the best session that we have, like in terms of the Q&A. So I think we have Ajit who is asking for mediation, is it necessary to appoint an advocate or client can approach directly to the council?
Mediation is all about the parties. It's not mandatory to have an advocate. On mediation, it facilitates the parties to speak. So therefore, it depends upon the complexity of your issue again. If it is a complex commercial matter, yes, you can have an advocate. But however, you will accompany with the advocate to the session. That is how it will happen.
Great. I hope, Ajit, that answers your question. Then we have Rajashekharan, who's asking, sir, what are the eligibility requirements to become a impaneled mediator?
Okay. Well, for that, I request the participants to refer to the Court Annexed Mediation Center rules, which has the qualification criteria. There are about, I think, 6 or 7 criteria is given. And there is a false perspective among the advocates that, only 10 years or more experienced advocates can become mediator. It is not so. If you look at the eligibility criteria set by even the court annexed mediation centers, it speaks about subject matter experts as a criteria. Also, if you are a certified mediator, then also you can apply for the empanelment. If you have attended the structured course on the mediation offered by various institutions, even the national law universities, they provide nowadays. So if you attend and get a certificate, attested certificate, then you can become an empaneled mediator. And the best thing is, we should be prepared. It is not a matter of becoming a mediator. It's a matter of becoming a relevant mediator to stay as mediator. So to stay as mediator, we need to educate ourselves. It is a lifelong process, and it is a self-reforming process as well. So therefore, it doesn't matter to get empaneled, but we have to get prepared for it.
Perfect, perfect. That does solves the question. And then we have Sona who's asking, please explain how council will take up a matter of mediation.
Say it again. How?
Sure. I'll repeat the question.
Yeah.
She's asking, please explain how council will take up a matter of mediation.
How council?
Yeah.
Which council? I think the question is not clear. Maybe we can allow the person to speak.
Sure. Sona, are you here?
Yes, sir. Sir,
Yes, please.
while explaining, you have told that it's
Yeah.
not necessary that a person should go. A council can take up any matter where already the agreement is there, a particular matter for mediation. So I could not get it. What was it?
Can you repeat? Sorry, I'm not also.
Yes,
clear.
sir. While explaining, you have mentioned that
Yeah.
there is a change in this act
Yeah.
where if the mediation agreement is existing,
Yes.
then a particular council can take up the particular agreement to specific mediation center.
Okay. Actually, the council I meant was MSEFC council. MSEFC Council, that comes under MSME Act, and that is a overriding act. Therefore, there the council itself can act as a mediator. Also, they can act as arbitrator later on.
Fine. Thank you very much, sir. Thank you.
Welcome.
Thank you so much. We have Advocate Rishabh who's asking, first of all, appreciating for the great session. And then he's asking, how can one be a part of Mediation Council of India and how can one get accredited or recognized as mediator?
That is yet to be established. So we have to wait and see. It is too early to discuss about that. It is in the act, but that is yet to be established by the government. That will come very soon.
Perfect. We have Dr. Chandra who's asking, it was mentioned that the foreign mediation settlements would not be recognized. How do you view this in terms of its acceptance with foreign parties?
Yeah, that is that is one of the downsides of the new act. But that will be addressed very soon. So taken care. That is what the mediation fraternity expects.
Can I just intervene and
Great.
ask a follow-up
Rest everyone
question?
can mute their yeah, thank you so much. Mute your microphones until you're asking. Yeah. We have Mr. Ajit who's asking, Mediation Act 2023 is amending few business laws like Company Act, MSMED Act, Consumer Act, etc. So are we going to see a change or an amended act of these prevailing laws, and by when?
Well, already it is part of the Mediation Act as schedules. If you look at the end of the act, there are 10 schedules given, and each schedule speaks about the amendments to the respective laws, whatever I have mentioned today. So that is already in vogue now. It's only matter of time. Yeah.
Great. We have another question from Advocate Raj Sekharan.
Yes.
Kindly let us know the fee structure to be paid to the mediator in commercial court cases or consumer matters.
Well, it depends upon the parties and the complexity of the matter. That is my personal experience. There is no fixed fee table as far as mediation is concerned. Yeah.
Makes sense. We have another question. Who's Advocate Mithilesh who's asking, just 1 second, could you name again the agency you work for empanelment as mediator?
Agency working for empanelment.
Yes, as mediator.
Well, there are private mediation service providers in India. I don't know whether I have to, I can name here in this forum. So you may Google it. There are a couple of private mediation service providers in India. So they do empanelment as well, and they do online mediation also. Otherwise, you have to approach the court annexed mediation centers. And in most part of the country, now even the taluk level also, mediation centers have set up. In my state, Tamil Nadu, there are about 30-35 taluk level mediation centers also have started now. So advocates, they can approach the respective mediation centers and they can empanel themselves.
Thank you so much, sir. We have a very interesting question coming up from 1 second. Yes, from Advocate Manish who's asking, suppose after reaching mediation agreement, if one of the party do not perform as per the agreement, then what will be the remedy?
Well, now that is the benefit of this act, isn't it? Like you have an arbitration award. What you will do? You will go for enforcement, right? So similarly, mediation settlement agreement, now it is enforceable under the act. So that is what the other party should do. They should approach the respective court and enforce it.
Perfect. I hope that answers your question. We have Ajit who's also asking, in all our contracts as we normally put arbitration clause, but should we now start inserting the provision of mediation, or we can put but arbitration and mediation clause? If we can insert both them, parties should approach which mechanism?
Well, that is a very, very pertinent question. Again, in my experience, it is always good to have multi-tiered dispute resolution clause. Why? Because arbitration or mediation, they are not fit for all disputes. There is no hard and fast rules. So therefore, it is good to have multi-tiered dispute resolution. For example, parties, they can start with amicable discussion, amicable negotiation. If it fails, then they can go to mediation. If it fails, then they can go to arbitration as the last resort. So this way, they have shopping list of options, and they will get expedited and at a very nominal cost of dispute resolution. Yeah. So to answer your question, the agreement, it should have multi-tiered options.
Great.
Yeah.
Thank you so much, sir. We have another question. For arbitration, we normally specify seat and venue. In case of mediation, is there something like seat and venue?
Not specifically mentioned here. Yeah.
Got it. We have Sampath who's asking that an arbitrator may be someone with technical background and not necessarily having legal background. Similarly, can a mediator be someone not having a law background?
Of course, that is why I said, you please refer court annexed mediation centers mediation rules. They have the criteria to become a mediator. And among the 6-7 criteria, there is one criteria. It says subject matter expert with a certain years of experience. And I am one among. I'm also an engineer turned advocate. So it is not an impediment. You need not be a lawyer. But if you are a subject matter expert, definitely you can become mediator. Yes.
Great. Thank you for that, sir. We have one more question. How jurisdiction will play a role in case one party is Indian and another is a foreign vendor?
Well, Mediation Act, it deals with only the domestic cases. It doesn't deal with the international disputes. So that is another downside with the act. That will be addressed very soon, I think. That is, already I mentioned about the Singapore Convention. Even though we are one of the signatories, it is yet to be ratified in India. So that is why it is not incorporated into the Mediation Act 2023. Yes.
Got it. One more question coming up. Just give me 1 second. Yeah. So during enforcement of mediation agreement, if party fails, then will it attract criminal proceedings?
Well, it is like enforcement of any other decree. There are two ways. Either the properties can be attached or the arrest. So the same will apply here also. Yeah.
Brilliant. We have Sampath who's asking, yeah, in international arbitration, the arbitrators as well as the experts are guided by a code of conduct. Similarly, is there a code of conduct for mediators also?
Definitely. The Act, it says about the disclosures, conflict of interest. So that is the hallmark of mediation as well as arbitration. So the mediator, he should be a real neutral.
Yeah.
He must be a real neutral, no compromise. Yes. So they shouldn't have conflict of interest, neither with the subject matter of the case, nor with the parties, nor with the counsels representing the case. It is as simple as that.
Great. I think we have some appreciation messages coming up. Thank you so much for enlightening us with all the queries and doubts. But we have one more question coming from Ajit, who's asking, can a mediation agreement be declared void if challenged in high courts?
Well, it is like any other contract, Contract, it has, well, it should be valid. It should have valid components, isn't it? So if it deviates from the valid components of a contract, then it will be void. So it is applicable to mediation agreement as well. No exception.
Great. I hope that answered your question, Ajit. I think Sampata is thanking you for all the wonderful answers, and many more appreciation messages are coming. Wonderful session, enlightened us to a great extent. If anyone still has any questions or any doubts, we still have a few minutes. We can take it up. There's just one last question I think we've received. Okay. All right. So, does the mediation council has the right to revoke the mediation agreement?
Well, mediation council is yet to be formed. So it is too early to speak about that.
Okay.
Yes.
Great. We have one more question coming up. An appointment of arbitrator can be challenged in case he's found to be biased.
Yes.
Similarly, under the Mediation Act, is there a provision dealing with a situation where the parties feel that the mediator is biased?
Of course. Also, mediation is a voluntary process. They can walk away anytime. They can walk out, parties. So that is the unique feature of mediation when compared to arbitration. Arbitration, of course, you have to challenge, go to court and all. Here, if you don't like the mediator, you can just walk out.
That's lovely.
Yes.
Great. I think everybody is just appreciating all the questions that you answered. We have more, a couple of minutes. If anybody has more questions, we can take it up. Okay. Is it a sole mediator or there are two mediators also like for arbitration?
Again, it depends upon the complexity of the matter. Normally, for the community mediation, they will have more than two mediators also. Yeah, depends upon the case.
Great. Okay. Perfect. Any other questions? Anybody? Yeah, we have one more. Okay. All right. I think this is more like a comment. We have a premature child in this new act. Premanant is saying. All right. Anybody else who has any questions? And feel free to put it on the chat box before we close. Okay. All right. So we have PGS who's asking, great session, but can it work for employment disputes?
Of course, yeah. It will. Only
Great.
whatever exempted under the Act, there is a exempted disputes under one of the
Right.
schedules. So except that, everything can be mediated.
Perfect. And I think we have one more question saying, second. Okay, so in all our contracts, as we normally put arbitration clause, but should we now start inserting the provision of mediation, or can we put? But I think this question was already asked before.
Yes.
Muzakir, I think sir already answered this question. We'll pick up another question that's coming up, which is, what if mediation was suggested as an ADR mode in contract, but the other party doesn't agree later?
Well, again, it is a voluntary process. Both the parties, they should be able to come forward. Then only it will happen.
Makes sense.
Yeah.
Great. All right. So, anybody, any more questions, or we can close this now? Yeah, I think there are no more questions. So, thank you so much, sir. Thank you so much for making this webinar an amazing learning experience for all. PPT and recording of the program with everyone will be shared within 7 working days. For further queries, please contact Experts Legal Team. Email us at connect@expertslegal.com or call or WhatsApp us at 9355999104. The dream of Experts Legal is to make each one of its members become highly successful in their career. Looking forward to working together. Goodbye to all of you, and thank you once again.
Thank you so much. Thank you.
Thank you, everyone. Thank you, sir.